Yes.
Okay. Yeah, she said that when they entered the room that she was grabbed by her hair, this would have been by Rhea, and then shoved to the ground and then kicked on the side and the head approximately 20 times. And when she was grabbed by her hair, it ripped some of her hair out.
And did she say where this occurred in the house?
This occurred in her bedroom in the basement.
Okay.
We will go on the record in the matter 26 CF43, State of Wisconsin versus Alicia Roseland. The state appears through District Attorney Kevin Schmidt in person. We have Ms. Roseland in person with counsel Eugene Harrington. We're set today in this matter for preliminary hearing. It will proceed. Please call your first witness, Mr. Schmidt.
I call Andrew Tyler.
Officer Tyler, please come forward. You're going to raise your right hand. You'll be sworn in, then come have a seat at the witness stand.
Do you swear that the testimony you're about to provide today in this matter is the truth, the whole truth, and nothing but the truth?
I swear.
All right, you may begin.
Can you state your name for the record?
Andrew Tyler,
What do you do for a living?
I'm a police officer for the Village of Siren.
How long have you been so employed?
Been employed there since August of 2025.
Did you respond to a call of a disturbance on March 21st, 2026 around 2:50 a.m.
Yes,
in Maple Lane in the Village of Siren?
yes,
Did you go out there?
yes.
Where did you go and what'd you see?
Went into the house. When I entered the house, I met the victim and she brought me downstairs. When I went downstairs, I met the two suspects and three victims at that time.
Before we get into that, the residence you went to, is it in
Mhm.
Burnett County?
Yes,
Okay. So you made contact with a number of people. What'd they say?
when I entered, the victim was upstairs. Initials D.O. was upstairs. She said they were downstairs. When I went downstairs, I was able to separate the two suspects from the victims, and they went upstairs. And I spoke with the two victims that were downstairs.
Who were they and what did they say?
Initials were JT and D.O. Said they were downstairs in the room when the suspects entered the house, went downstairs, entered their bedroom, and attacked them.
You said suspects. Did they know who attacked them?
Yes, it was Alicia and Rhea.
They specified it was those two.
Yes,
You actually saw the Alicia who was there.
yes, she was in the basement when I entered the house.
Do you see that person in court here today?
Yes, she's seated next to the defense counsel in a black sweatshirt.
Let the record reflect that Officer Tyler has identified Alicia Roseland.
Did Dio or JT describe the circumstances leading up to them being attacked?
Yes, they said they were in their room.
Object to the form of the question. We need to know who said what, whether it was JT or DO. Which person said what?
I get the whole victim's rights and Marcy's law, but we don't have to use initials. This is a formal hearing. Please use the names. All right, so that is sustained.
Who did you talk to?
We talked to Jack Taylor and Desiree Otto.
Did any of them say how the circumstances led up to the attack?
Yes,
Who and what did they say?
they both said that.
That's the form. There has to be a specific identifying who's speaking.
That's why I said who and what did they say?
And that's a compound
The
question.
compound question sustained.
Who did you talk? What did Desiree say?
Desiree said she was in her bedroom and the two suspects entered the house, went down to the bedroom, entered the bedroom, and attacked her and Jack.
What did Jack say?
He said that he was in the bedroom and they came in and attacked him in the bedroom.
Did Desiree give any more details about how the attack went?
At that time, she said that later on she did give more details. Do you want me to go into what was said later on?
Yes.
Okay. Yeah, she said that when they entered the room that she was grabbed by her hair, this would have been by Rhea, and then shoved to the ground and then kicked on the side and the head approximately 20 times. and when she was grabbed by her hair, it ripped some of her hair out.
And did she say where this occurred in the house?
This occurred in her bedroom in the basement.
Okay. Same question for Mr. Taylor. Did he give further explanation of the circumstances of him being attacked?
He did. He did not know the suspects at the time. He said that one female entered and attacked him. And he said that the other one began attacking Desiree.
Okay. Were there any recordings of the incident that you reviewed?
Yes, there was. Lisa, the homeowner, Desiree had called Lisa and left a voicemail. And in that voicemail, you could hear female, presumed to be Desiree, screaming. You could hear and you could hear a female voice saying, "Go, Rhea, for your grandpa," and saying "go" multiple times.
Was there any explanation given of what the connection of Alicia Roseland and Rhea Shabash was to this residence of the people there?
Yeah, so Rhea was a foster child of the owner of the house. She had been there approximately, I believe it was till she was 6 years old.
That was quite a long time ago.
Yes.
And did the owner of the house indicate whether they had permission to come in?
Yes, she said they had no right to be there.
Okay. Did you talk at all to either Rhea or Alicia?
Yes.
What did Rhea say about the incident?
Rhea said that there was a conflict at a bar in town. She said that she had went to the house to confront Desiree. She said that Rhea said that it was her grandpa's house. So she entered the house, went downstairs to the basement. She said that they met her by the bathroom, Desiree, and then she did not know what happened after that. It moved to the bedroom and she did not know.
What did Alicia say?
Alicia said that she said that it was Rhea's house, and that I'd have to reference the report to see exactly what she had said for entering the house.
Would it refresh your recollection if you reviewed the criminal complaint?
Yeah.
Got it.
Okay. So
Objection, I want to know what page
okay.
he reviewed first, Judge, and then not to read the page, but what did he review?
What
Okay.
pages have you reviewed, or did you review the entire criminal complaint?
I reviewed pages 1 through 4 up to 4 of 8 to read.
Please put the document down or
Okay.
give it back to Mr. Schmidt, and then
Okay.
he may answer the question.
So specifically, Alicia, when asked what had happened, she kind of chuckled, looked at Rhea and said, "How do I explain this?" Or "How do we explain this?"
Is that all she ever said?
She mentioned that it was Rhea's house and that's why they went there.
Okay. Did you ask either I guess I should say the full name, either Jack or Desiree if the attack caused them injury or
Yes,
pain?
yes,
What'd they say?
yes. They both confirmed that it did. Talked to Jack later and he confirmed that it did. I reviewed body camera and observed Desiree had wincing in pain when her head was touched. And then she said she did have EMS. She did get looked at by EMS at that time.
Were there visible injury to her?
Yeah, she had a small cut on the back of her head, blood behind her ear, and she said she could taste blood.
Did she indicate whether she gave consent to being attacked?
She said she did not.
How about the same question for Jack?
He said he did not.
When Rhea was explaining that she went over there about something at the Pheasant Inn, was she saying that happened the same day?
Yes. Yeah, she said it was approximately 10 minutes earlier.
Okay. I don't recall if I asked this, so if I'm repeating it, just let me know. You identified who the homeowner was?
Yes.
Who was that?
Lisa
And did she say whether Rhea and Alicia had permission to enter the residence?
Yes, she said they had no right to be there.
Okay. Did she know Alicia at all?
She knew Rhea through being a foster. I could not recall if she knew Alicia.
And just for clarity, when Desiree was explaining who was attacking her, did she say it was only Rhea or only Alicia or something else?
She said that they had both entered the room and attacked her. Later, she said that it was Rhea that was the one that had pulled her hair down. And she said that Alicia had attacked Jack at that time.
Okay. I have no other questions.
Mr. Harrington?
Thank you, Judge. Did you check the public record to see who actually has title to the real property?
I asked the
Did you
homeowner.
check the
No,
public
I did
record?
not.
There is nothing in your reports or the criminal complaint that indicates that Alicia pulled Desiree's hair, is there?
No.
There's nothing in the criminal complaint to suggest that Desiree kicked, that Alicia kicked Desiree either, is there?
Not in the, no.
And the source for the information that Alicia attacked Jack comes from Jack, correct?
Yes.
Alicia told you that Jack struck her first. Did she not?
I do not recall her telling me that Jack punched her first.
Okay. But you don't recall that.
There-
That's not in the complaint either, is it?
Mhm. No, it's not in the complaint.
Have you talked to, no, I'll withdraw that. Do you know what the disagreement between Alicia and, strike that. Do you know what the disagreement between Rhea and Desiree was about, other than some family thing?
I do not know the specifics. I know that Rhea or Alicia at the time had said that Desiree had said something to her at the bar, called her name.
Thanks. I have no further questions.
Questions? Redirect?
No redirect.
You may step down. Thank you, sir.
Move to dismiss, Judge. There's no, are you done? Kevin, I'm sorry. I jumped the gun here.
Further witnesses?
No other witnesses.
I'll move to dismiss. There's no evidence that they entered this premises without the lawful consent of the owner, because someone self-represents that they own the property. Isn't conclusive as a matter of law as to who actually does. Further, there's no evidence that Alicia kicked or stomped or did anything vis-a-vis Desiree or Jack. Jack has an interest in this, and he self-reported that Alicia punched him, and there's no other evidence in the preliminary exam to suggest that that's an accurate recitation of the facts. The state has failed in its burden. Move to dismiss.
Mr. Schmidt.
I think we showed the lawful possession with all reasonable inferences drawn in favor of the state. What needs to be shown for burglary is not title ownership, it's lawful possession. And we've definitely shown that here with the statement from the woman that she's been there for over a decade because she knew Rhea because Rhea lived there as her foster child in 2006, I believe, is what the officer testified to. So she plainly had lawful possession and plainly said these people didn't have consent. In fact, what was described is that a person named Desiree insulted Rhea Shabash, and then Rhea Shabash and her friend went to the house to seek her out to make good on that on their own. I'd also know everything that Attorney Harrington said about who did a battery or not is irrelevant because that's not one of the elements of this offense. The element of burglary with intent to commit battery is whether you have the intent to do it. If a battery actually happens, that's just an enhancer. So I think all reasonable inferences draw in favor of the state. I think one can conclude that these two people, after seeing this insult at a bar, went across the street, went to this house for the purpose of settling up. And even if Mr. Harrington wants to discount that the officer did testify that Desiree said both of them attacked her, which the court should not, this is party to a crime liability that's shown with like the voicemail showing only other person there who was supportive of Rhea attacking this person could have been Alicia Roseland. That's also reasonable inferences. So I'd ask the court to bind over.
Judge, one comment.
Rebuttal, yes.
There's no identification that the person overheard on the telephone cheerleading, in essence, is actually Alicia.
That's why I said it's a
And
reason.
secondly, Judge, the defendant's not charged with party to the crime. She's charged with actually committing the act. I'll concede that can be solved quickly with the information.
And it can be, and I understand your argument and where you're going, Mr. Harrington. And this is a preliminary hearing and the court has to determine whether there's probable cause to have a felony charged. Defenses are not something that the court can take into play in a preliminary hearing. I can't make any determination of truthfulness of anyone's statements. I can't go to credibility. I can't view the evidence like a jury would. I have to take the statements and the evidence as presented, and it was presented through the testimony of the officer. Cases that have conflicting inferences means the state wins, and there's enough to at least bind it over where a reasonable officer here with training and he reasonably believed that a felony was probably committed and therefore was charged. In viewing the evidence in the light most favorable to the state, bound over. Information, Mr. Schmidt.
I filed the information. It mirrors the criminal complaint.
Proceed with an arraignment or set for another date, Mr. Harrington.
Can we set this for another day simply because it's a technical defect, but I think it has to be charged as a party to the crime. And if Mr. Schmidt is charging these as pled in the information in the complaint, I want to have an opportunity to look at that before I have my client plead. So
Yes, I understand.
another day, please.
Mr.
Two things I'd say to that is if you look at the annotated statute for party to a crime, it says it does not need to be alleged. Also, by having the prelim, you waived any arguments against structural defects.
But here's the thing, this is a discussion that attorneys can have outside of the presence of the courtroom. Therefore, I'm going to set it for another date. You can figure it out. Does May 28th at 9:15 work?
Judge,
Oh, you're fishing.
I'm fishing in Canada. I'm sorry. How
No,
about
that was my mistake thinking you're only going for a day.
how about June 9th, July 9th at that 10:30? That'll.
Nope, that's way too far. I can do 6/1, June 1st.
I'll
at
be here on
1:45.
another case on June 1st. That'll work.
What time are you here? I didn't look. I don't know what time you're here, but we can figure that.
Mr. Harmon's bail hearing. I think that's it. I left a notice in the truck.
Oh, you are here at 1:30. So June 1st at 1:30, we'll have an arraignment. We can preset that other July date for a status if that's what you would like.
That makes sense, Judge.
Let's preset a status for July 9th at 10:30. July 9th at 10:30. Arraignment will be June 1st.
1:30.
We set a status and an arraignment?
Yeah, just to keep them on the same path, the co-defendants. All right, Ms. Roseland, you can come up here and get your notice and you're free to go. Thank you. Waiver for both?
We're not going to waive, Judge.
You're not waiving?
No.
Mr. Fisher, can you hear me?
Yes, Your Honor.
Is this a waiver or are you having an actual hearing?
Your Honor, ours was going to be a waiver.
All right. So I will call 26 CF 44 State of Wisconsin versus Rhea Shabayish. Appearances are, we have Ms. Shabayish appearing in person. Her counsel, Zachary Fisher, appears by video conferencing. We're set today in this matter for a preliminary hearing, but the court's been informed that this is a waiver of a preliminary hearing. And that's correct, Mr. Fisher?
Yes, Your Honor. I have received an offer from Attorney Vila and I've discussed it with my client, and based on that information, we are going to be waiving at this time.
Okay, all right. So Ms. Shabayish, did Mr. Fisher go over with you what it is to have a preliminary hearing?
Yeah.
And that you would be able, or that the burden is on the state to prove a felony was probably committed and probably committed by you? Can you bring the microphone and can you speak verbally into it, please?
Yes.
And do you understand that by waiving your right to a preliminary hearing, you are agreeing that the state can at least meet that burden?
Yes.
Do you understand at a preliminary hearing, your attorney would be able to ask questions of the state's witnesses, the law enforcement officer here. He'd be able to call witnesses to testify for you. You'd be able to testify if you wish. He'd be able to produce evidence on your behalf or possibly discover things about the case, which could include defenses. But for today's purposes only, you're giving up those rights?
Yes.
Do you understand at a preliminary hearing, if the state does not meet its burden as to that felony, that means that I could amend it to a misdemeanor or dismiss it altogether, but you're giving up that right?
Yes.
Do you understand that once you give up the right, it's forever and you cannot get it back?
Yes.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yes.
All right. I will find that you are competent, you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I will find probable cause and bind the matter over. Information, Mr. Schmidt.
I filed the information. It mirrors the complaint.
Proceed with an arraignment or set for another date, Mr. Fisher.
Your Honor, we can proceed with the arraignment today. We'll enter not guilty pleas to all counts, waive speedy trial, and ask to set this for status conference.
Not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. What I'm going to do is schedule this. How about July 9th? And you pretty much have your pick. I only have one scheduled there right now at 9. So would you like 9:15 or any other time that morning?
I could either do 9:15 or 10:30.
All right, let's put you on at 10:30. So July 9th at 10:30. All right, thank you. We are adjourned.
Thank you, Your Honor.
Thank you. And we'll wait for Ms. Roseland. And then we will go on the record in the matters 25 FO 269, Village of Siren versus Alexander Plaster, 25 TR 627, County of Burnett versus Alexander Plaster, 25 TR 747, State of Wisconsin versus Alexander Plaster, 25 TR 764, Village of Siren versus Alexander Plaster, and 26 TR 300, County of Burnett versus Alexander Plaster. Appearances are, we have the state appearing through District Attorney Kevin Schmidt in person. Mr. Plaster appears in person we have Chelsea Whitley appearing by video conferencing capability. We're set today in these matters for status conferences and an intake for, I believe, another matter that has been filed, 26 TR 300. I can find that one. That new one is an operating with restricted controlled substance first. Initial appearance, at least at this time, not guilty plea will be entered on his behalf. Mr. Plaster, you were given an opportunity to speak with an attorney and or to retain an attorney if you had wished to do so. An offer was presented. Otherwise, we have multiple trials to continue and move forward with. The offer, I believe, was to plead to the OWI first for the lowest cost, and all other matters would be dismissed and read in. Would that also include that the operating with restricted controlled substance first, 26 TR 300, Mr. Schmidt?
Yes, it's the same offense as this.
Just a different filing date? All right, so all matters would be dismissed and read in for purposes of sentencing, including that underage drinking, including the operating with a restricted controlled substance in your system, and the other tickets and matters, with the offer of pleading to the OWI first for the lowest payment, the lowest guidelines. That's still all acceptable and good?
Yes.
Ms. Whitley?
Yes, it is.
So, Mr. Plaster, what is it? What, are you going to accept the offer, or are we going to have trials?
I just got a question. Would that 6-month suspension be credited for what I said already? Or?
I would do that, yes.
Okay, so would my license still get suspended again? Or?
Well, I have to order it be revoked for 6 months, but I could order with any credit for any administrative suspension you've already received. And then it would be a matter of you going to the DMV, but the court would order that you could get any credit for a suspension you've already received.
So would I have to reinstate it again, or?
You have to go and pay a fee
Okay.
and do those things. And you would also have to do an OWI AODA assessment.
I'm already attending something like that.
Excellent. Then if you're doing what you need to do, it sounds like you're doing what you need to do. So knowing those things, do you wish to accept the offer?
Yeah, I'll do it.
All right. So that would be 25 TR 627 operating a first offense. This is a forfeiture. You do not have a right to have an attorney or a public defender. You could retain one for you. You would have the right to a trial. You would have the right to have your attorney or yourself cross-examine the state's witnesses or call witnesses to testify for you. You would have the right to testify on your own behalf or remain silent and not have your silence used against you. You would also have the right to have a jury trial, but in a case like this, it's only 6 people, and only 5 out of the 6 need to reach a decision by what's called clear, convincing, and satisfactory evidence, not beyond a reasonable doubt. And you would have the right for the state and the Village of Siren to prove your guilt by clear, convincing, and satisfactory evidence. So do you understand those rights?
Yes.
And you're pleading guilty today to operating while under the influence, a first offense?
Yes.
As a forfeiture? Are you admitting here today that you in fact did operate while under the influence?
Yes, I did move the vehicle.
All right, okay. And so you wish to be pleading guilty?
Yes.
The court will accept your plea of guilt. And you're asking for lowest guidelines, Mr. Schmidt?
Yes, he was at the lowest guideline on the alcohol, and there was a small amount of THC.
So $936.50, 6 months revocation of driver's license?
Yes.
All right, the court will order $936.50, 6 months revocation of driver's license. No ignition interlock device is needed. OWI assessment and follow through, including the driver's safety plan, 6 points off of your license. I will give you credit for any administrative suspension you've already received. And so that will go on the judgment of conviction. All other matters will be dismissed and read in.
Okay, and I got a question. Can I set up a payment plan down there for the fine?
You certainly can, or we can take care of this right now. You are working, are you working full-time?
Yes.
$100 a month?
Yeah, that's fine.
All right, $100 a month to be paid to the clerk's office. Failing to pay that timely means not only will the court enter a civil judgment against you because you're always going to owe it, but I will also issue a warrant. You could sit up to 6 months in jail.
Okay.
If there comes a time where you're having a hardship and you don't think you can pay for it 1 month, or you need a little bit of a time to be able to pay, you must write a letter or call Amy here, our clerk over here, and talk to her, because you don't want a warrant to be issued.
Right.
Okay?
Okay.
Anything further, Mr. Schmidt?
No.
All right, then we are adjourned. Thank you.
Thank you.
Armstrong?
Yes.
All right. We will go on the record in the matter 26 CM 28, 26 CM 29, State of Wisconsin versus Matthew Ramstrom. The state appears through District Attorney Kevin Schmidt in person. Mr. Ramstrom appears by telephone conference with approval of the court. We're set today for a status conference. Mr. Ramstrom participated in and completed a domestic violence course through an online course. The offer was to have him do the Dave Hatch Restorative Justice course and plead to an ordinance violation. Mr. Ramstrom, were you able to complete that program?
I thought it was like the whatever you sent me on. I Googled it and I did the one.
Again, we went over this at the last hearing. We went over this at the last hearing, that was what the court ordered on your bail bond. But that is not the offer from the state. But I do have
now you want me to meet with a guy, with some fella?
That's Mr. Schmidt.
Okay.
No, Mr. Schmidt is looking at the case. He's the district attorney. He has final say in the cases. This is an actual ADA case, but the ADA is off today.
Because that course definitely covered a range of things.
It's not for you to negotiate with the court. It's not a negotiate with the court thing. It's a negotiate with the district attorney.
I see that my assistant reviewed what he did online. He did think it should satisfy it. So my indication here is because he did that, the offer would be DC for costs only.
So plead to a disorderly conduct,
Yes,
not an ordinance, the misdemeanor.
that's what his notes seem to indicate.
All right. So he will accept that course that you did, and the offer is plead to a disorderly conduct without any domestic abuse attached for costs only. Are you accepting that offer, Mr. Ramstrom?
What does that mean? That I still pay a fine?
Yeah, it would be a fine, a court fine for the case.
Yeah, like we were talking before.
Correct.
Okay. And then this is closed and
Then it's
done with?
closed and done.
Okay, yeah, because this has been exhausting.
All right. So you are appearing by telephone conference. Do you understand you have the right to be here in person?
Yes, Your Honor.
And do you wish to settle this matter and take a plea and be sentenced by telephone conference?
Am I looking at like jail time or something?
The offer is for just the fine.
Okay. Like no probation or jail and nothing like that?
Well, that's what the offer is from the state. Yes, to plead to a disorderly conduct for a fine only.
Okay, which is like I don't get it. Like you're trying to put me in jail?
Mr. Ramstrom, the offer from the state is plead to a disorderly conduct. They're going to recommend to the court that it's only a fine. Yes, the court could, if I thought that this was serious, if I thought that this was cray-cray serious, and that you should be punished more. I could, as a judge, punish you more, and I could, as a judge, sentence you to 90 days of jail. However, the recommendation from the state, because you did that program and it exceeded what they were expecting, is for costs of fine only.
Okay.
So do you wish to accept that offer?
Yes.
All right. And you're pleading and being sentenced by telephone. Do you wish to continue today by telephone, or do you want to set it up for an in-person date?
For what?
To
For
be,
payment?
no,
Thought you were gonna
to
take
be
it out of
here.
bond.
Sir, for court.
Okay.
I need to know if you want to take care of this today by telephone, or if you want to say, you know what, Judge, I'd rather be there in person and I'd rather look at you in the face when I get told what a disorderly conduct is and what all the things mean. I'd rather be in person. Do you want to be in person or by telephone?
Isn't it just a misdemeanor?
Yes, it sure
Like a
is.
misdemeanor?
It is surely duty, highly lily, a misdemeanor.
Well,
It's what I have to do, sir. I have courts that say that there are certain things that I have to do on my job, on the
Okay.
record. That's one of the things I have to ask you. Do you want to do it by telephone, or do you want to be here in person?
no, Your Honor. I'm fine doing it by telephone.
Excellent. Formal motion to remove domestic abuse enhancer.
So made.
Granted. So, Mr. Ramstrom, how old are you?
40?
Can you read, write? You understand the English language?
Yes, ma'am.
Any drugs, alcohol, medications, or mental illnesses or disorders?
No.
Do you understand you would have the right to go to trial? You would have the right to an attorney. You would have the right to have yourself or an attorney cross-examine the state's witnesses or call witnesses to testify for you. You would have the right to testify on your own behalf or remain silent and not have your silence used against you. You would also have a right to have a jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you would also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of that?
Yes, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand the state would have to prove on or around February 7th, 2026 in Burnett County, Wisconsin, in a private place, you engaged in abusive or otherwise disorderly conduct, which tended to provoke a disturbance. That is a misdemeanor. Maximum possible penalty could be a fine of up to $1,000 or 90 days of incarceration or both. Do you understand that charge and what the maximum penalty could be?
What it could be, but we've already negotiated what the penalty is, right?
Again, I can do what I want. I'm the judge. But that is the recommendation.
Well, maybe I will
So,
take this to trial. I don't know why. I don't know why you can't.
sir, I just
agree
have
on
to do my
something.
job, sir. And the law
Okay.
makes me say all these things on the record, sir.
Okay. Yes, I understand.
All right, that could be a maximum possible penalty. The recommendation, again, from the state is a fine and costs only. So you understand that if I thought that this was outrageous and very abusive and very violent and very harassing, I could sentence you up to 90 days.
I understand, Your Honor.
All right, okay. Now, are you admitting here today that your behavior that day would meet the definition of the disorderly conduct under Wisconsin law?
Not at all.
You don't think you were
Maybe-
disorderly
maybe
or you
my
provoked a
language
disturbance?
After the
Oh my
fact,
God, you
but,
are awful.
um,
You're coming here in person and we're going to do this in person. I can't do it because A, you want to talk over me all the time. B, I can't look at your eyes and say, shut up. C, you're not understanding anything.
No, I understand fully. Like, I was out of line.
You were out of line. And what I'm asking you,
I was
The
not
definition-
supposed to be having contact.
the definition I gave you for disorderly conduct, your conduct that day was otherwise disorderly and it provoked a disturbance, correct?
Correct.
So you're pleading guilty to the disorderly conduct because you're guilty of that conduct, correct?
Correct.
All right. Has anyone threatened you or promised you anything for you to plead guilty today?
No, ma'am.
You're doing so freely and intelligently. That means you are telling the court you fully understand what you're doing
Yes, ma'am.
and voluntarily.
Yep.
Do you have any questions for the court or for Mr. Schmidt, the district attorney, before I proceed?
No, Your Honor.
As to count 2, disorderly conduct without an enhancer, how do you wish to plead?
As guilty, I guess.
Are you guessing it or do you know it?
Yeah,
You're pleading guilty?
correct.
All right. The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of disorderly conduct. The remaining charges and the other case will be dismissed and read in for purposes of sentencing. Judgment of conviction will be entered today. Argument, Mr. Schmidt.
This is minor behavior around an injunction that has since been dismissed. This is appropriate. I'd ask that you follow.
Mr. Ramstrom, what do you want the court to know? Anything? You can make a statement.
No, Your Honor.
All right.
Just like this all to be over with so I can go on with my life.
I understand the facts of this case. I understand the facts of you and your ex, or the mother of your children. I understand the situation. It is not, does not rise to an entirely serious level. You are admitting responsibility and being accountable and pleading guilty to a disorderly conduct. So I do think that it's appropriate. I don't think you're a risk to the community. Therefore, the court will follow the recommendation, $500 cash. You have that posted. You are good to go. No further money is owed to the court. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need to order your DNA. You need to call the sheriff's department and see if they have it. If they do, you're good to go. If not, they'll just come in and request that you provide a swab of your DNA. But in a case like this, you do have the ability to request it be expunged from the CODIS system through a written letter to the Department of Justice, the Wisconsin Department of Justice, not to the court. All right, anything else?
All right.
Not from me.
Nope, I understand that.
All right, then we are.
As the courtroom battle continues, prosecutors insist the evidence points to a planned attack, while the defense argues there isn't enough proof to hold Alicia Rosland responsible. With the judge allowing the case to move forward, the final outcome will now be decided in the next stages of court. What do you think? Should this case go to trial? Let us know in the comments.